So good morning, everyone, and welcome to the City of Stockton's Emergency Rental Assistance Program's informational webinar in partnership with the California Rural Legal Assistance. We are very excited to be here this morning and provide our city residents with information as rent relief and eviction protections are still available in Stockton. My name is Carmen and I am from El Concilio. We have two panelists that are joining us today that are going to be answering common questions that we have collected from our call center, from tenants, and then also from landlords. At any time, if you have any questions, go ahead and use the question and answer box at the bottom of your Zoom screen and type in any questions you have, and we will get to those at the end of the webinar. We are going to start off with allowing the panelists to introduce themselves and their program and the services that they are providing to our residents. And then we will start with common questions, and we will conclude with questions and answers directly from our webinar attendees. So without further ado, we are going to go ahead and get started, and Felicia Hall is going to introduce herself.
Hi, everybody. My name is Felicia Hall. I'm with El Concilio. I'm the program coordinator for the Emergency Rental Assistance Program. We're happy to have you here. So a little bit about our program is we provide assistance with rent and utilities, as well as other rent-related costs. So this program is designed to prevent homelessness and to help create housing stability. We're very happy to announce that we've helped, 3,930 households. And I'm going to pass it over to Marisol. Thank you.
Good morning, everyone. My name is Marisol Elias. I am a community worker with California Rural Legal Assistance. I work out of our Stockton office. Our Stockton office provides free legal assistance to San Joaquin County residents in the areas the areas are housing, like eviction defense, housing discrimination, habitability, retaliation. We also help with employment, like unpaid wage issues, employment discrimination, retaliation, health and safety issues. We also assist with public education, such as school discipline, including suspensions and expulsions, language access issues and special education. And we also help with public benefit issues like CalWorks and CalFresh and Medi-Cal issues, as well as supplemental security income, also known as SSI, and general assistance.
Thank you, Marisol. Felicia, will you kind of describe a little bit of the rental assistance and other services that are available through the Emergency Rental Assistance Program?
Yes, so we do offer up to 18 months of assistance starting from April 1st, 2020. So if you're past due, let us know, apply. We urge you to apply. We can assist you with your past due and 3 months of future rent. That's the most months we can do in increments as far as for future rent. We also help with utilities, and we are now offering relocation services. So if you guys are needing to move, we can assist you as long as you're within the Stockton city limits. If you're relocating to anywhere in Stockton. If you need help with security deposits, moving truck fees, security storage fees, application and screening costs, we also help with hotel motel expenses as well. So if you're needing somewhere else to stay, we are offering relocation services.
Perfect. Thank you so much, Felicia and Marisol, for that information. We are going to go ahead and get started with common questions from tenants that our call center has received. So the first question is, now that the moratorium has lifted, can my landlord kick me out if I am registered for the Emergency Rental Assistance Program?
Sorry, I was trying to unmute myself here. So if a tenant has submitted an ERAP application and it's pending or approved, landlords cannot move forward with an eviction. Landlords who want to move forward with an eviction on a non-payment of rent case must submit a sworn statement that are there, and there are certain things that they have to state, like, for example, include documentation that a tenant did not furnish completing their portion of an ERAP application. Also, landlords cannot engage in self-help lockouts. For example, like changing the locks and shutting off the utilities. This is against the law.
Awesome, thank you. Second question is, can the landlord apply on my behalf and not let me know?
So generally, if a landlord or tenant apply, the other side is notified and has a portion of the application that they also need to complete.
Alicia, you have anything to add to that, or is that pretty good?
I do have something to add. So the landlord can apply on behalf of the tenant as long as they can provide their ID, proof of income, and they're actually a resident of their property. So say if the tenant does abandon the property and they still have rent that's owed to the landlord, as long as they can prove that, they can apply.
Thank you both very much. Next question is, can the landlord come into the property without my permission?
So owners have a right to enter the property. However, they must issue a proper written notice stating when they plan to enter the property and the reason. There are certain circumstances in which landlords may enter without notice if there is an emergency, like, for example, if the tenant is not home and there is a flood.
Thank you. Next question is, if my landlord is harassing me, what rights do I have?
So tenants have a right to live in a dwelling free of harassment from a landlord, and they have a right to quiet enjoyment of the premises. If a tenant fears for their safety, they may need to involve the authorities. It is also good to document and keep track of the harassment, like, for example, saving any text messages that the landlord is sending. Also, the Fair Housing Act protects harassment based on protected traits such as a race, disability, national origin, sexual orientation, familial status, and gender.
Thank you. Next question. My landlord has been paid through the Emergency Rental Assistance Program, and now he is harassing me to pay additional money. And if I don't pay, he is threatening to kick me out. What should I do?
So landlords should not be asking for additional payments if they have been paid in full for any rent owed. It is important to document everything and to keep track of payments made to the landlord in case the landlord wants to bring forth an eviction action. And again, landlords cannot engage in self-help lockouts.
And the next two questions kind of go hand in hand. So it's stating, can you please explain the difference between a 3-day or a 15-day notice and being served eviction papers? And then the second part to that is, when a tenant receives a 3-day notice, how many days do they have until they have to vacate? So a lot of questions on eviction notices. So if you could just kind of walk us through both of those.
Okay. So this is a great question. So the 15-day notice to pay rent or quit was required as part of the temporary COVID-19 Tenant Relief Act of 2020, which was extended a few times and ended on September 30, 2021. During the protected period, if a tenant was unable to pay rent, landlords had to serve a 15-day notice to pay rent or quit, along with a blank copy of the COVID-19 Declaration of Financial Distress. Now that the protections have ended, the law reverted back to the 3-day notice to pay rent or quit, which was a requirement prior to the pandemic. It is important to note that the 3-day notice period does not count weekends or court holidays. And then also there are other types of 3-day notices, like for example, a 3-day notice to perform covenant or quit, which means that a landlord is claiming that a tenant has not complied with a term in their lease, and they're giving that tenant 3 days to comply. Let's see. Now, in regard to the eviction paperwork, so if a notice expires, like for example, if a tenant is served with a 3-day notice to pay rent or quit, let's say, and the tenant doesn't pay within the 3 days, if it's not like COVID related, like this is just like for example purposes. So if the tenant does not pay the rent within the 3 days, then the landlord can go ahead and file eviction paperwork with the court once the notice expires. And then that's like the start, that starts the process, the formal eviction process through the court, which is called an unlawful detainer. And there was another part to that question. Would you mind repeating that question for me?
Yes, of course. It says, when a tenant receives a 3-day notice, how many days do they have until they have to vacate?
So the eviction process, it's a process to be able to evict someone from a home. And it's hard to give like a timeline because it is meant to be a quick process, but it all depends on how fast the landlord moves after the notice expires and whether or not they're represented. So there's several factors that come into play with that. So it's hard to give like a specific like timeline.
Okay. The next question we have is, can a landlord refuse to give me an updated ledger after they have received the emergency rental assistance grant?
They should not. However, if a landlord refuses, a tenant may make the request in writing so that they can create a paper trail of the request made. Also, tenants should be able to get a copy of payments through the program so that they can keep for their records. And I don't know if Felicia may want to add a little bit to that as well.
So it is the tenant's right to know what's been paid on their behalf, and also vice versa. So if the tenant applies and they got assistance, it's also the landlord's right to know what's been granted.
So is that just something where they could call the ERAP office and they can get that info?
Yes, and if they registered and they have a registered account, they can also log into their portal. On the case info screen, it shows exactly what's been paid out.
Okay, perfect. And when you, Marisol, when you said they can request in writing, is that like a certified letter in the mail? Is that an email? What, or either of those valid?
I think either of those are valid, but probably the best way to go maybe certified, just because it's a better way to keep track of documents and then to further prove that that other side received it, versus with email. It is a good communication source, but landlord might say that they didn't receive.
Okay, perfect. Thank you. Next question, can tenants get kicked out after a new charge after they have been already living there and they've already been paid through the emergency rental assistance program? For example, increased rent, City of Stockton water bill, etc.
So it depends on what type of fees the landlord is requesting and for what time period. If it is a rent that was not covered by the program, then they may issue a 3-day notice to pay rent or quit. However, if it is an unexplained charge and the program has covered all fees and everything is current, a landlord should not be trying to evict the tenant. And again, landlords cannot engage in self-help lockouts.
Thank you for that. Next question, if I paid a pet deposit, but it was after I signed the lease, can they still evict me for breaking the lease if I have proof that I paid the pet deposit?
So if the lease provides for a pet deposit and the pet deposit is paid, then a tenant should not be evicted for failing to pay the pet deposit. It is important to review the terms of the lease for specifics on the language for the pet deposit.
Okay. Next question is, if my roommate decides to move out, how can I get them off the lease?
So it depends on the lease terms. Again, it is important to review lease terms. If a tenant is under a fixed term lease, like for example, 6 months or a year, they may request that their landlord agree that they be allowed to break the lease before the lease expires. If a landlord does not agree to break the lease, then a landlord does have a duty to attempt to release the unit. However, the tenant may be liable for the months that the unit is unoccupied.
Okay. If I was funded for 3 months of future rent and move voluntarily before the 3 months end, can I get the credit from my landlord?
So this is a tricky question, but it's still a good question. If a tenant paid out of their own pocket for the 3 months in advance, and provided proper notice that they were vacating the unit before the 3 months are up, then a landlord may need to refund the tenant, or a tenant can also sue in small claims court if a landlord refuses to refund the funds. Now, if the rent was paid by a rental assistance program, the money may need to be credited back to that specific program. However, this question may be better addressed by that specific rental assistance program directly based on their specific rules.
Felicia, you have anything to add to that?
So yes, if you do vacate before the 3 months is fully exhausted, all the funds are fully exhausted, the landlord, it is illegal for the landlord to give the money directly to the tenant. So the landlord would need to, we would need to recapture the funds and put it back into the program.
And we are currently working on a way to do that online through the portal, correct, Felicia?
Correct. So it will be noted when the landlord does return the funds back to the program, it will be noted in your case. So in the event that you do need additional assistance for the future, we can reflect that from the previous payment that he returned.
Awesome. Thank you both so much. So those are the common questions that we had from tenants. We are going to switch now to common questions that we have received from the landlords directly. So the first question from a landlord is, can I still evict my tenant if they are participating in the program? I know we touched upon that again, but if you could just review that one more time, that would be awesome.
Yes, certainly. So a landlord may not evict for COVID-related non-payment of rent issues that a tenant has applied for through the ERAP program and has been granted the funds. However, if an eviction is for something else, it will depend on the specifics as to why the landlord wants to evict. Hope that helped a little.
Yes, thank you very much. Next question. If I have a credit from the program and the tenant has abandoned the property, can I give the tenant the credit or do I have to give it back to the program?
So this question is similar to the last question from the tenants. So the funds may need to be credited back to the program. However, the landlord may need to contact that specific program directly in order to obtain more guidance on that.
And I think Felicia clarified that in the last question as well, as that they will need to return it to the emergency rental assistance program directly. Okay, next question. If the tenant has been paid through the program but has not paid me the money, can I evict them?
So landlords have the burden to prove the reason for evicting a tenant on non-payment of rent eviction cases. So it depends on the facts of the case, but landlords do generally have a high burden to prove the reason as to why they're evicting a tenant from their property.
So Alicia, do you want to kind of explain the 15-day? Okay.
Yeah, so I'd like to add to that. In the terms and conditions of the program for the tenants, it states that they have 15 days after receiving payment. That also doesn't include weekends or holidays to turn over the payment in full to the landlord, or they may still be at risk of facing eviction. So that is a part of our terms and conditions for the program.
Thank you for that. Next question. If I decide to sell my home, how long of a notice do I need to give the tenant?
So it depends. If a tenant has a fixed term lease, then the lease terms should be followed. Also, assuming that there is no fixed term lease, there are other factors that may need to be considered, and notice requirements. For example, if the property is subject to the Tenant Protection Act of 2019, that limits the reasons for evicting, or whether the tenant and landlord are participating in the housing choice voucher program, such as Section 8. So it depends on a number of factors.
Okay. And if someone had a specific question, they can always call and ask their specific question, correct?
Yes, and I actually was going, if you don't mind, I did want to go over something just really quickly that, so this presentation does provide, it's meant to be for general information only. Landlords and tenants should seek legal advice for their specific cases, just so that they are aware of, their rights and whatnot.
Are you going to share your screen, Marisol? Or you want me to move on to the next question?
Oh, that's fine. Sorry, move on to the next.
We have one more question and then we can go ahead and let you share your screen, okay? So final question from the landlords was, can I decline to receive money from the program if I have other reasons other than non-payment of rent to evict my tenant?
So if a landlord refuses to accept money from a rental assistance for COVID-related debt, then they cannot evict for non-payment of rent. If there are other reasons for the eviction, then it will depend on the reasons, and the landlord should seek legal advice at that point.
Perfect, thank you. So that concludes our common questions from landlords. So Marisol, if you want to go ahead and share your screen.
Yes, I can. And it's, I'll go ahead and just mention what since we've already gone through like the questions, I just wanted to give out like a special shout out to the city of Stockton and then Concilio for allowing us to be part of this Q&A, and the city of Stockton. So we are excited to be able to work with the city of Stockton in providing additional housing services for our Stockton residents. And we do have a housing tenants rights flyer that I will be sharing with you all so that you may be able to share it with the rest of the community, if that's okay.
Yes, perfect. We'd love that. The more information and resources that we can provide for the community, the better it is for everybody. So thank you so much for the information. I think we're going to go now to the question and answer box. So if any of our attendees have questions, make sure you guys enter them into the Q&A box, and then we will go through them. So first question that we have in the box is, you mentioned that the protections have expired. The protections for California are still in place as the governor has not lifted the state enacted protections, and the city of Stockton has extended its protections based on the state's protections. So I think they're asking about, are they still protected or not from evictions?
So there are still protections. What I was discussing was what I meant was the COVID-19 Tenant Relief Act of 2020 that was extended a number of times, and I don't recall all of like the specific, like it was SB 91, AB 38, I believe, and I think the last one was AB 832. Don't quote me on it because it's hard to keep some of like the numbers. But That's what ended. It was the Tenant Relief Act of 2020 that those protections ended as of September 30, 2021, but there are still protections set in place. And if a tenant has like an issue or housing issue or an eviction issue, I strongly recommend that they reach out to our office, and I can drop our information in the chat box so that everyone has that. Sorry, hope that helps.
Okay. A second question that we've received in the chat box is tenants are coming to the Emergency Rental Assistance Program office concerned because their landlords are telling the tenants that the tenants will have to pay the amount the landlord gets taxed for receiving this assistance. So Felicia, can you clarify kind of what the landlords will receive? Will they in terms of tax purposes? And Marisol, maybe you can clarify the tenant's responsibility as far as tax concerns.
Yes, so all the landlords that are participating, they do fill out a W-9 because this is considered taxable income. So the way we see it is they were already going to be paid rent, which they should be reporting on their taxes. So that, from what I understand, that's not the tenant's responsibility. It's the landlords. Marisol, you want to confirm that?
Yeah, I think that's a bit of a tricky question for me. So I think that how you answered it was great. I can check in with our office as well if they have any more guidance on that.
Yeah, because then the second part of that question is they have expressed concerns because they have been told by the landlords that they're going to take a portion of the assistance received to pay the taxed amount. So.
Yeah, I'll make a note of that question and get back to you all, to Carmen and Felicia.
Perfect, thank you. And then another question in the chat that we have received is that tenants are saying that some landlords are taking advantage of them because they had the tenants pay 20% of their rent during this time, and now they have received emergency rental assistance funds for the 100% of the rent. And so the 20% that they paid has not shown up on their ledger. So what rights do they have in terms of the 20% that they received, that they paid?
Okay.
So
Yeah,
when the landlord is refusing to give them like an updated ledger showing, reflecting money that the 20% that they have paid, or they don't want to give them a receipt for money that rent that they paid, what rights do they have?
I want to say that maybe this question can be answered through one of like the, I want to say one of the questions that I went over.
Mm-hmm.
And I think it's one where they can make that request in writing and
Right.
keep documentation or track of, the payments that have been made, and also follow up with the program that they're getting the assistance from. But I can also get more clarity from our office to see if there's anything else they would like to add.
Perfect, thank you. The last call for any questions from our attendees that you want to put in the Q&A box before we wrap up the webinar. I know a lot of information, a lot of questions from both tenants and landlords, just trying to figure it all out. I don't see any other questions coming through. So on behalf of El Concilio, I want to thank Felicia and Marisol for taking the time this morning. And Felicia and Marisol, if you guys could kind of share your contact information and the best way to contact your offices if anyone has questions pertaining to their case or situation that they have, please, I'll give you guys the floor to share that information, and then any closing remarks you would like to make.
Thank you, everybody, for participating. I'm going to put our contact information in the chat. So we do have a high volume of calls, so we do suggest that you email. We're pretty diligent about responding to emails. I'm going to also be providing that in the chat as well. Just keep calling, guys. And if it is urgent, please stop by. We do have walk-ins available Monday through Friday. We're open from 6 a.m. to 6 p.m.
Thank you, Felicia.
Thank you. Thank you, everyone, for joining the event this morning. Thank you for Concilio for allowing our office to be part of this. We really appreciate it. I dropped our contact information in the chat box. Our office is open to the public Mondays and Tuesdays, and Wednesdays, Thursdays, and Fridays. We're open by appointment only, but our phone lines are always open. And then we also have an answer to an unlawful detainer every Monday at 10 a.m. to noon. So if in case anyone is interested, and if you've been served with eviction paperwork and you would like to know like the eviction process and guidance on how to complete the forms, please reach out to our office to sign up for our workshop. Thank you, everyone.
Perfect. Again, thank you, Felicia and Marisol, everybody for attending. Thank you very much. And we hope you all enjoy the rest of your weekend. Please reach out with any additional questions to our Emergency Rental Assistance Program or the CRLA. So thank you very much, everybody. Bye.